As you near the end of the treatment phase of your case, you may reach a point at which one of your physicians says that you have reached maximum medical improvement. What this means is that additional treatment is not likely to improve your symptoms and injuries. It may be the case that you will require ongoing maintenance treatment, but that treatment will not be expected to make you any better off than you were before. It is critical in a personal injury case that you reach maximum medical improvement. Because with personal injury cases, you only get to make one claim to the insurance company or bring one lawsuit against the defendant. And that claim and lawsuit has to include both the past medical bills and past injuries that you've incurred and the future medical bills and future injuries that you may yet incur as a result of the accident. Until we know what the nature and extent of your injury is, which we will learn as soon as you reach maximum medical improvement, until we have that information, we cannot reliably forecast what the future is going to look like for you and what future medical care you may need. Once you've reached maximum medical improvement, the next step for your case will be the demand phase, in which the attorney and the paralegal will help prepare a demand brochure to present to the insurance company. So the insurance company would not pay a fair and reasonable amount to settle your case. And now, your case is in litigation. The first step of litigation is to file a document with the court called a complaint. The complaint is a brief document that lists out allegations about the accident and allegations about the damages that you've sustained in the accident. For strategic reasons, this document will be stated in very general terms and may be quite brief. It merely is intended to give the defendant enough notice about the nature of your claim and also the damages that you are seeking as a result of that claim. Once the complaint is filed, the lawsuit will have begun, and from there, the complaint will be sent out for service upon the defendant. Once the complaint is served on the defendant will have 21 days to answer the allegations in the complaint. After the defendant has answered those allegations, the parties will exchange the documents that they intend to use at trial and identify the witnesses that they believe may have evidence or information important to the case. That phase of exchanging documents and making an initial identification of witnesses is called initial disclosures. And that phase takes usually a month to complete. Once that phase has been completed, the case will go into a phase that is called discovery. We will, of course, need your cooperation and input as we draft the complaint and as we prepare your initial disclosures. Your input will be needed to help us identify witnesses who may be able to speak to your injuries, how they have impacted your life, and how you are doing still to this day. So think about people who may be effective witnesses in that regard. Spouses, family members, friends, people that spend a good deal of time with you and can talk about just how much this accident has impacted your life. We will be calling you to get information not only about witnesses, but any other types of documents or evidence that you may have, including photographs, videos, and other type of information that may be helpful to your case. So please think carefully about the type of evidence that you may have access to and keep an open line of communication with us so that we can assist you to litigate your case fully and vigorously.